all eyes, all eyes, Judiciary, all eyes, all eyes, all eyes, Judiciary, all eyes, all eyes, all eyes, Judiciary, all eyes.
Yeah, that's right. All eyes on the
Judiciary, all eyes, all eyes, all eyes on the Judiciary.
Yes, all eyes on the judiciary. As the Election Petition Tribunal sitting in the Court of Appeal Abuja is set to pass a judgment that is seeking to disqualify Bola Ahmed Tinubu presidency as declared by the INEC. Now, there is no doubt that there is tension on every camp. Even the Labour Party, the PDP, AMP, any party at all that is even expecting victory or cancellation of election, there is also a tension in that party. But above all, the APC is jittering because they know that Tinubu will not survive this court case. So that is one of the reasons why there is tension as the tribunal have set to give judgment. This video has the details.
The Presidential Election Petition Court is sitting in Abuja has reserved its judgment on petitions seeking to remove President Bola Tinubu from office. The Justice Haruna Samani-led 5-member panel of the court okayed the cases for judgment after all the parties adopted their final briefs of argument. The two petitions marked CA-PEPC 05-2023 and CA/PEPC/03/2023 were brought before the court by former Vice President and candidate of the People's Democratic Party, PDP, Alhaji Atiku Abubakar, as well as the candidate of the Labour Party, LP, Mr. Peter Obi, respectively. While adopting their final written address, Atiku and the PDP, through their team of lawyers led by Chief Chris Uche, a senior advocate of Nigeria, urged the court to declare that President Tinubu was not qualified to contest the presidential poll held on February 25, 2023. Atiku and his party alleged that the Independent National Electoral Commission INEC, despite receiving over 355 billion naira for the conduct of the election, deliberately bypassed all the technological innovations it introduced for the purpose of the 2023 general elections. They contended that INEC breached the amended Electoral Act when it refused to electronically transmit the presidential election result. On the issue of transmission of election results based on new provisions in the Electoral Act, we're all in agreement, including the INEC, that there is a new regime in election management. The essence of the innovation was to enhance transparency in the collation of results, which was an area where we usually had problems, and not the actual election, and secondly, to strengthen the integrity of the results declared. We agreed that INEC had an option, and we brought video evidence by INEC chairman showing that the electoral body indeed chose an option. It is our contention, and it is herein evidence that witnesses admitted that results from the National Assembly election were transmitted, but that of the presidential election was not. My lords, in a situation like this, the burden shifts on INEC to explain. It is not on the petitioner to explain why there was such technical glitch. We urge this court to hold that there was a deliberate non-compliance. The substantiality of the non-compliance lies on the national spread of the non-transmission of results. It was national and not limited to certain polling units, Uche SAN added. While adopting his own final brief of argument, Obi and the Labour Party, through their lawyer, Levi Uzoku, senior advocate of Nigeria, argued that there was no glitch during the election, but an intentional act to sabotage the outcome of the poll. Uzoku SAN, while calling for the removal of President Tinubu, insisted that an election where over 18,088 blood results were uploaded to INEC's IREF portal is certainly a flawed election. Meanwhile, all the respondents in the two cases, INEC, President Tinubu, Vice President Kashim Shettima, and the All Progressives Congress APC, through their respective lawyers, prayed the court to dismiss the petitions as grossly lacking in merit. INEC's legal team, led by Abubakar Mahmood SAN, maintained that the presidential election was validly conducted and substantially complied with all the relevant laws. The electoral body argued that the petitioners misconstrued and totally misunderstood the purpose of the technology it introduced for the 2023 general election. It told the court that the bimodal voter accreditation system BVAS device was introduced for the authentication and verification of voters and for transmission of results from the polling units to the IRF portal. INEC's lawyer argued that no evidence was presented to establish the allegation that INEC made use of an electronic collation system in any election that was conducted in the country, adding that such a system did not exist. Mahmood told the court that INEC used a manual collation system, admitting that the commission experienced a technical glitch that lasted over 4 hours on the day the presidential poll was held. He said it was not true that the glitch was contrived to create an avenue for results of the election to be manipulated. The petitioners have failed to establish that there was human interference that led to the said glitch, and they have also been unable to prove how the failure to upload results in real time affected the outcome of the election. On the issue of Tinubu's alleged failure to secure 25% votes in the FCT, INEC's lawyer accused the petitioners of inviting the court to adopt an interpretation that will result in absurdity. INEC told the court that it was illogical for the petitioners to claim that a candidate must secure 25% votes in the FCT to be declared winner of a presidential election. It argued that such argument would run contrary to the spirit and intent of the drafters of the 1999 Constitution, as amended, adding that FCT ought to be regarded as the 37th state of the Federation that is without a special status during elections. Similarly, President Tinubu and Vice President Shettima, while adopting their written address, urged the court to dismiss all the petitions. Addressing the court through their team of lawyers, led by Chief Wole Olanipekun, SAN, the duo said it would not be in the public interest for the court to set aside the decision of the electorates that led to their victory at the poll, arguing that the petitioners ultimately failed to discharge the burden of proof as required by the law. Chief Olanipekun SAN further accused both Atiku and Obi of merely dumping documents before the court. He told the court that his clients won 1/3 of the votes in the FCT, adding that Obi had no locus to challenge the outcome of the election since his name was not found on the register of the Labour Party. On his part, counsel to the APC, Prince Lateef Fagbemi SAN, urged the court to hold that Tinubu scored over 25% in about 29 states, adding that to do otherwise will amount to constitutional absurdity. He argued that Obi was overambitious in his petition when he requested for a rerun poll, notwithstanding that he would not be legally qualified to participate. Fagbemi SAN stressed that all the issues the petitioners raised against President Tinubu have all been decided by various courts. On the issue of the forfeiture order by the court in the USA, Fagbemi SAN argued that it was not an indictment that was capable of disqualifying Tinubu from contesting the presidential election. After adopting the written addresses, Justice Haruna Samani adjourned the matter for judgment at a date to be communicated to all the parties.